Hey everyone! Today we're diving into a critical issue that's been making headlines in Canada, the ongoing struggle of First Nations communities for clean drinking water. The Canadian government is currently facing a class action lawsuit, spearheaded by the Shamattawa First Nation in Manitoba, for its failure to provide clean water to Indigenous communities. This lawsuit argues that access to clean water is a fundamental human right, one that Canada is legally obligated to fulfill. However, the government's stance is rather controversial. They argue that providing potable water is a discretionary political decision, not a legal duty. Now here's where things get even more complicated. Justice Canada lawyers representing the government maintain that there's no specific legal obligation to operate and maintain water systems for First Nations. They claim that the government's support for clean water initiatives is good governance, not a legal requirement. This has sparked outrage, especially given Canada's international reputation as a human rights advocate. Adding fuel to the fire, there's a clear discrepancy between the government's legal arguments and previous public statements made by Liberal ministers. Indigenous Services Minister Patty Hajdu admitted back in 2022 that the government has played a role in the water crisis faced by First Nations. Yet, the government now says these statements were made in a specific context and should not be seen as legal opinions. Critics argue this is an attempt to downplay the severity of the situation and avoid accountability. The class action lawsuit includes 59 First Nations and potentially many more individual members, aiming to hold the government accountable for the ongoing water crisis. Despite Prime Minister Justin Trudeau's 2015 campaign promise to eliminate all long-term boil water advisories on reserves by 2021, numerous communities still lack access to safe drinking water. While progress has been made in lifting over 145 long-term advisories, critics argue the pace of change is far from sufficient. Emotionally charged testimonies have brought to light the harsh realities faced by these communities. Shamattawa Chief Jordna Hill described the cross-examinations by government lawyers as long and painful. He criticizes the government for trying to shift blame onto First Nations leaders instead of acknowledging systemic failures. Lawyers for Shamattawa First Nation accuse the government of using unfair tactics, including aggressive questioning and overwhelming the plaintiffs with technical documents on short notice. Moreover, the government's legal team submitted an 11-page appendix outlining alleged inconsistencies in the plaintiffs' evidence, which some see as an attempt to discredit First Nations leaders and undermine their claims. These allegations of victim blaming and procedural unfairness have only fueled public outrage and cast a shadow over Canada's commitment to reconciliation with Indigenous peoples. The outcome of this case could set a significant precedent for Indigenous rights in Canada. It highlights the urgent need for genuine action from the Canadian government to ensure the basic human right to clean water for all its citizens. Stay tuned for more updates on this critical issue. Thanks for watching, and don't forget to like, subscribe, and hit that notification bell to stay up to date with timely trends and news. Thank you for watching.